Sadly, but predictably, Israel chose to ignore the court's ruling, showing that it considers itself above the law. Israel's hideous conduct, which piles illegality upon illegality, is well documented. Its most ruthless application has been the siege conditions imposed over the Gaza Strip since October 2023. Israel's failure to ensure and facilitate unhindered humanitarian assistance to the population of Gaza would surely be seen as an integral part of this crime against humanity. Israel ignored those orders, as it has similar calls made by other UN bodies, international organizations, and concerned states. Instead, it has exacerbated the humanitarian crisis and turned the Gaza Strip into an unlivable pile of rubble, while killing thousands of innocent and vulnerable people. Mr. President, distinguished members of the court, it's an honor for me to appear before you to present my country's views on a matter of critical importance for the United Nations, all states, and in particular for the Palestinian people. Mr. President, on behalf of my country, the Kingdom of Saudi Arabia, I would like first to congratulate you on assuming the presidency of this court. Mr. President, distinguished members of the court, less than a year ago, the court held that Israel's policies and practices in the occupied Palestinian territory, including its settlement practice, its continuing occupation, and its annexation of parts of that territory are flagrant violations of international law that must be brought to an end as a matter of urgency. The court's ruling marked a clear path for Israel to follow in finally bringing itself into international legality. Sadly, but predictably, Israel chose to ignore the court's ruling, showing that it considers itself above the law. Outrage over Israel's conduct, particularly since October 2023, has compelled the UN General Assembly to return to the court to seek its guidance on another pressing matter. This time, the question placed before the court and the circumstances which have brought it about are of more immediate and extreme importance. Those circumstances include the General Assembly's alarm over the impunity with which Israel has continuously blockaded the provision of humanitarian, life-saving, and other desperately needed assistance by the UN and other concerned parties to the Palestinian population throughout the occupied Palestinian territory, most egregiously in the Gaza Strip. Confirming the obligations of Israel to allow the United Nations, other international organizations, and third states to carry out activities in the occupied Palestinian territory, including providing such assistance, could truly make the difference between life and death for many people. Israel's hideous conduct, which piles illegality upon illegality, is well documented. Its most ruthless application has been the siege conditions imposed over the Gaza Strip since October 2023. As the entire world is painfully aware, diseases, lack of sanitation, clean water, food, shelter, and medical care is endemic, while temporary respites have occasionally occurred. Israel has reimposed conditions of total blockade at will, just as it did in early March this year, completely halting the provision of food, water, medical supplies, temporary housing, fuel, and anything else to the starving, displaced, and exposed population of the Gaza Strip. Nothing justifies such barbarity. Israel's blockade of humanitarian assistance and simultaneous brutalization of the civilian population throughout bombardment can only be understood as two components of a single enterprise, namely a means for bringing about the ethnic cleansing of the Gaza Strip, displacing or killing its Palestinian population to make room for Israel to settle and annex the territory. Israel's failure to ensure and facilitate unhindered humanitarian assistance to the population of Gaza would surely be seen as an integral part of this crime against humanity, if it were ever to come to pass. And of course, withholding such a humanitarian development assistance also plays a role in a larger Israeli undertaking, that is, to demolish the established right of the Palestinian people to self-determination by undermining their ability to survive and stand on their own. The court is aware of the appalling circumstances faced by the population of the Gaza Strip and their dire need for humanitarian assistance on a sustained basis. The court has issued provisional measures in South Africa versus Israel on 3 occasions, ordering Israel to take all necessary and effective measures to ensure the provision of desperately needed humanitarian assistance to Palestinians throughout Gaza. Israel ignored those orders, as it has similar calls made by other UN bodies, international organizations, and concerned states. Instead, it has exacerbated the humanitarian crisis and turned the Gaza Strip into an unlivable pile of rubble, while killing thousands of innocent and vulnerable people. Mr. President, distinguished members of the court, on or around April 15th of this year, the Palestinian death toll in the Gaza Strip reached a grim figure of 51,000, some 15,000 of them children. Over 116,000 people have been wounded. These figures increase every day, even during the short periods of so-called ceasefire. It's not difficult to understand why, as the Israeli military has removed all restraints on killing innocents. It has conducted over 40,000 airstrikes on the tiny strip. Terrifyingly, it employs artificial intelligence to determine who to kill and who to spare. Establishes kill zones where anyone crossing invisible boundaries, even women and children, is shot on sight. Bombards so-called safe zones, killing countless innocents, many while sheltering in flimsy tents. And denies requests by international organizations to import equipment required to clear the estimated thousands of unexploded Israeli ordnance scattered across the Gaza Strip, which have killed or maimed numerous innocent Palestinians. Adding to these catastrophic conditions has been the systematic destruction of hospitals, water infrastructure, agricultural land, bakeries, homes, and other vestiges of life throughout the territory, creating conditions of suffering, disease, and starvation. The request now before the court seeking to clarify the obligations of Israel to allow international organizations and states to provide humanitarian assistance and operate within the occupied Palestinian territory, including Gaza, must be seen in this context, as it explains why the request has such urgency and importance. As shameful as Israel's conduct towards the Palestinian people is, the harm it caused them not the only damaging consequences of that conduct, nor the only reason why the question before the court has such importance. Another critical reason to establish the scope of the Israeli obligations encompassed by the General Assembly's request is to clarify the legal framework for evaluating Israel's actions against the UN and other international organizations and third states seeking to assist the Palestinians within the occupied Palestinian territory. Israel's hostility towards the UN is too lengthy to summarize here. Its attacks have been particularly aimed at UNRWA, which since 1949 has played an indispensable role in safeguarding the basic rights and living conditions of the Palestinian people who were displaced from their homeland, providing health care, education, food, and other assistance to some 5 million refugees. As emphasized by the UN Secretary General, when it comes to providing humanitarian relief and assistance to the people of Gaza, there is no realistic alternative to UNRWA. Israel's hostility against UNRWA began long before the current crisis. However, since October 2023, its attacks have intensified dramatically. Israeli forces have killed over 200 UNRWA employees, attacked and destroyed their premises, ransacked their warehouses, and denied entry to UNRWA relief supplies. Israeli police have stood by while UNRWA's premises in Jerusalem were attacked and burned by an Israeli mob. Israel also ordered UNRWA to vacate its premises in occupied East Jerusalem and has passed laws prohibiting Israeli authorities from having any contact with UNRWA and preventing UNRWA from operating within Israeli territory, which it illegally claims includes occupied East Jerusalem. The excuses Israel has given to justify its actions, claiming that UNRWA lacks neutrality, promotes biased narratives, and is infiltrated by Hamas, have been addressed by the UN and discredited. Moreover, an independent review led by the former French foreign minister found Israel's allegation to be unsubstantiated and lacking of any credible evidence. The fabrications underlying Israel's action against UNRWA and against the UN more generally cannot be seriously doubted. What those actions establish, however, is the court's opinion about Israel's obligation encompassed with the General Assembly's request is urgently required, not just to prevent further harming the Palestinian people's right to receive humanitarian development support, but also to safeguard the legal foundation in which the UN and other entities conduct humanitarian activities. Turning to the court's jurisdiction, our views and the views of almost every other state participating in these proceedings are in agreement that, given the legal questions raised, the court has jurisdiction to issue the requested advisory opinion, and that there are no compelling reason for it not to do so. On the contrary, given the inhumane conditions to which Israel has subjected to the Palestinian people, most terrifyingly in the Gaza Strip, we respectfully submit that the court is under a duty to issue its opinion so that Israel's obligation to ensure and facilitate the provision of humanitarian assistance by the United Nations, other international organizations, and third states are made clear. Furthermore, the General Assembly's inquiry on Israel's obligation impact matters of widespread importance, including the operations of the UN and other aid agencies, as well as Palestinian rights, a matter of universal concern since the adoption of Resolution 181 in the second session in 1947. The requests also highlight urgent issues, including Israel's legislative ban on UNRWA, military actions impeding humanitarian aid, and threats to the UN privileges and immunity. A small minority of a group and states argue that the court should refrain from issuing this advisory opinion because doing so would require it to undertake a significant factual investigation, which is not appropriate for an advisory opinion, or that the question was formulated in a biased manner. These arguments, which were rejected by the court in the Wall and the Israeli policies and practices cases, would be similarly dismissed for the same reasons articulated in those decisions. The same states argue that the court should decline to give this opinion because it has already addressed the subject of the request in its previous advisory opinions related to the occupied Palestinian territory, or that rendering the occupied would prejudge the ongoing contentious proceedings in South Africa versus Israel. These arguments have no merit. The present request is self-evidently distinct from the prior requests, as the scope and nature of Israel's obligations to ensure and facilitate the provision of humanitarian assistance by the UN, other international organizations, and third states was not expressly addressed by the court in either of those advisory opinions, leaving the court views in that regard unknown. As for the argument that these advisory proceedings would prejudge the outcome of the genocide case, that argument fails for obvious reasons. As for the argument, these advisory proceedings would prejudge. In South Africa versus Israel, the court is called upon to interpret and apply the Genocide Convention and to determine whether Israel's conduct in Gaza engage its international responsibility under that convention. To a significant extent, the answer to that question is whether the requisite intent under Article 2 of the Convention can be attributed to Israel. The answer to the questions raised in these proceedings, which are broadly focused on identifying the obligation of Israel to ensure and facilitate humanitarian and other assistance throughout the occupied Palestinian territory, and do not ask the court to determine Israel's responsibility under the Genocide Convention, and would in no way prejudge that narrow question. Turning to the question before the court, I will highlight only a few key points. First, as an occupying power, Israel is bound by international humanitarian law, in particular the Hague Regulations of 1907 and the Fourth Geneva Convention. Under those norms, and at the bare minimum, Israel must guarantee the basic needs of the population in the occupied Palestinian territory at all times, including the provision of food, water, shelter, and medical supplies. It must allow medical personnel to carry out their duties and must not adopt measures amounting to collective punishment. But Israel's obligations do not end there. Pursuant to Article 59 of the Fourth Geneva Convention, if an occupying power is unwilling or unable to fulfill its duty to provide the whole or part of the population of the occupied territory with essential supplies and services, as obviously the case in Gaza, it has an absolute duty to facilitate such provision by international organizations or third states. These obligations are unconditional and are supplemented by Article 69 of Additional Protocol 1. These obligations are, in the case of Israel, complemented by the duty of raising under Security Council resolutions not to obstruct, attack, or impede organizations and states from providing urgently needed humanitarian development assistance to the population in the occupied Palestinian territory. As an occupying power, Israel's international human rights law obligations are also engaged. Under these obligations, Israel must respect, protect, and fulfill the fundamental human rights of the Palestinian people in the occupied Palestinian territory. These include their right to life, to the highest attainable standard of physical and mental health, to an adequate standard of living, to adequate food, clothing, housing, water, and education. The obstruction by Israel of efforts by international organizations, including the United Nations, or by third states to provide basic services and assistance to the Palestinian people under occupation in order for them to enjoy such protected human rights entails a clear violation of Israel's human rights obligations. As a UN member and as a party of the UN Convention on Privileges and Immunities, Israel has further obligations relevant to these advisory proceedings. Under Article 2, subsection 2 and 2, subsection 5 of the UN Charter, Israel must cooperate in good faith with the United Nations, giving it, quote, every assistance in any action taken in accordance with the Charter, end quote. Israel's obligation to provide every assistance in good faith to the United Nations encompasses the principal UN organs as well as other UN subsidiary organs, including UNRWA. As UNRWA's mandate is to provide humanitarian assistance to the Palestinian people, Israel duty-bound to give every assistance to UNRWA in good faith. The attempt by certain states in these proceedings to limit Article 2, subsection 5 as only applying to enforcement action by the Security Council pursuant to Chapter 7 of the Charter is incorrect and contrary to this Court's interpretation of that provision in the Reparations Advisory Opinion. Under Article 25 of the Charter, Israel has also agreed to accept and carry out the decisions of the Security Council. Israel must therefore comply with the Security Council resolution demanding that it give unhindered access to those providing humanitarian assistance to the Palestinian people. Israel also has a duty to guarantee that the UN enjoys the legal capacity necessary for exercise of its functions and fulfillment of its purposes. This duty is enshrined in Article 104 of the Charter and Article 1, Section 1 of the Convention on Privileges and Immunities. Moreover, Israel is under a duty to guarantee the United Nations and its officials the privileges and immunities necessary for the fulfillment of their functions. The obligation is contained in Article 105, subsection 1 of the Charter and was further developed in the Convention on Privileges and Immunities. That convention provides that the United Nations, as well as its officials, property, and assets, are immune from every form of legal process. Recently enacted Israeli laws that target UNRWA by revoking its privileges and immunities and allowing potential criminal proceedings against UNRWA. Officials breach these duties. Finally, the Convention states the undisputed principle that the premises of the United Nations shall be inviolable. This obligation has several implications. First, Israeli authorities may not enter the premises of the United Nations or its organs without their consent. Second, Israel has a positive duty to protect and safeguard those premises from external threats. And third, Israel must not attack those premises. Importantly, these obligations are not qualified and do not cease to apply in situations of armed conflict. Thus, Israel's failure to guarantee the inviolability of UN premises can never be justified on grounds of military expediency or national security. I now turn to Israel's obligation to respect the Palestinian people's established right to self-determination. I use Cogan's norm, generating obligations erga omnes. If that obligation is to mean anything, it surely requires, at a minimum, that Israel allow the provision of humanitarian development assistance to the Palestinian people by those prepared to give it so as to strengthen their ability to achieve self-determination. Israel's refusal to comply with that imperative while perpetrating unspeakable violence on the Palestinian people can only confirm the war's fears about its intentions. The Court's voice confirming the scope and nature of Israel's obligations to ensure and facilitate humanitarian development assistance to the Palestinian population will serve as a powerful force in preventing those fears from becoming a reality. In closing, the Kingdom of Saudi Arabia wishes to emphasize that the Palestinian people's right to self-determination is at the core of the question before the court. The Kingdom takes this opportunity to reaffirm its unconditional commitment to the establishment of an independent and sovereign Palestinian state with the 1967 borders with East Jerusalem as its capital. This unwavering position is non-negotiable and is not subject to compromises. Mr. President, distinguished members of the court, thank you for your attention. This concludes the statement of the Kingdom of Saudi Arabia.